Next, from the state capitol, the House Judiciary Committee hears testimony on HB 5425. This bill would require that, following a divorce, the non-custodial parent would get at least 35% parental visitation time per week, unless they are deemed unfit. We'll hear from both supporters and opponents of the bill. This runs about 40 minutes.
Thank you, Madam Chair and members of the committee. House Bill 5425 amends the Illinois Marriage and Dissolution of Marriage Act, provides that the court shall allocate parenting time according to the child's best interest, and that it is presumed that it is in the child's best interest to award equal time to each parent. Provides that in cases where the court finds that it is not in the best interest of the child for the parents to have equal time, or that it is not possible for both parents to share time equally, a minimum of 35% residential time per week should be ordered from the non-custodial parents. And I've got several witnesses here that will also like to give a short testimony, and then we'll answer any questions. I'd also respectfully ask for an aye vote.
So we have 25 pages of witness slips, so I will dispense with the reading of all of those witness slips. But there's for several folks seeking oral testimony. I think what I had discussed with the sponsor is that we would be taking, I see 3 people sitting at the witness table, so we'll take those 3, and we'll give you 2 to 3 minutes apiece. So if you can identify yourselves for the record when you start to speak, and then we'll know we can be able to compare that to the witness slips. So whenever you'd like to proceed, and I will be keeping time.
Yes, Madam Chair, members of the committee, thank you for inviting me here today. What this bill does is it presumes both parents are fit. It creates a rebuttable presumption that allocation of not less than 35% residential time is in the child's best interest. And it provides procedures for filing of parenting plans where parenting plans aren't agreed by the parents, that the judge will help in providing the parenting plans. Now, what I read is what the bill's about, but the words I read were the exact same words that are the recommendations of the Illinois Family Law Study Committee. The Illinois Family Law Study Committee was formed by the House in 2008 to look at the laws and bring them up to date with social science. I know that the committee testified, or members of the committee testified before you on May 22nd, 2013, reinforcing these concepts. They discussed how many years that they spent looking at the social sciences to ensure that our laws were drafted based on current science. This committee consisted of lawyers, judges, representatives, and people who are experts. The custody subcommittee that helped make these recommendations, they voted on these concepts 6-0. It was unanimous. And when it went before the full Illinois Family Law Study Committee, the vote was 11-6 to make these recommendations to place in the law. What the bill does not do, it does not touch domestic violence. We abhor domestic violence. We have not touched anything. The Illinois Domestic Violence Act still prevails and preempts anything here. Additionally, we believe this bill will reduce domestic violence. With the more parenting time, there's less issues. Parents fight over time with their children. That's the biggest fight I have in court. I'm an attorney in Chicago. That's the biggest fight that we see there. What this will do is allow more parenting time, which means there will probably be exchanges at the school, so there's less interaction between the parents. They'll pick up the child from school, they'll drop off the child at school. The midweek will be typically pick up on whatever day it is, drop off the next day. So once again, there will be less chance of domestic violence. The way this works is, first the parents are determined to be fit, and then from there the parents will come up with a parenting plan between themselves. It's not up to the judge. If they cannot come up with a parenting plan, then it'll go to the judge, and the judge will determine a parenting plan based on best interest. Right now, I guess the question is, do we already have parenting plans in place? And how much discretion does the judge have? I'll tell you right now, there is a parenting plan in place, and the judge has no discretion. Anyone here in this room can tell you a non-custodial parent's parenting plan. It's every other weekend, 1 day during the week. Go anywhere, and that's what it is. Everybody knows it. I can pull from a couple jurisdictions that they actually have rules that if the parents don't agree, it's every other weekend and 1 day during the week. So there already are parenting plans. What this does is place our parenting plans within the social science, and it's purely based on the recommendations of the Illinois Family Law Study Committee, who looked at this for many years at the science. I believe next we have Dr. Bedell.
Right at 3 minutes.
Thank you.
Hi, I'm Dr. James Bedell. Madam Chairman, rest of the committee members here. I'm kind of coming from the, the trenches side of this, having worked in the mental health field for 35 years. I'm a licensed clinical psychologist. I have been a instructor at Columbia College and have taught in the areas of child development and family systems. I have done numerous custody evaluations in the early part of my career. I gave those up for personal reasons. I have done a tremendous number of 215 evaluations for fitness. I've worked with thousands of children within the context of my practice, my private practice up in Cary, where I have had to deal with the what I call the psychiatric injuries of children who have gone through the process of divorce. I truly believe that divorce in itself does not have to create a context in which children have to be traumatized or have to be injured. However, the adversarial nature of the sort of milieu of the court system starts with the concept that when a couple divorces, they automatically get turned into adversarial opponents. It's an adversarial process. You see your partner as the enemy. You're fighting for certain things, children being one very important one. And in any kind of adversarial process, a lot of assumptions develop, like if I, can somehow put dirt on the other person, maybe that'll up my position of strength as it comes to my ability to take territory, the territory of the children's time. And so there's a contentiousness, there's a perception, there's a going-in concept, what I call a presupposition, that when a couple divorces, they are going to war. It's just within, it's endemic inside the concepts of the adversarial system of resolution of parenting agreements that we're going to war. I've heard many clients that I have say it's going to be a bloodbath, and they say it right off the top. They say it's going to be a bloodbath that's going to bankrupt us. So there's concepts that float within the culture that say the resolution of these kinds of issues, this shared parenting time, are going to result in some extremely detrimental processes. And then what happens, what I see as a therapist, as a psychologist, is the very process of this contentious atmosphere creates the kind of emotional distress inside the parents that create injury to the children. Kids are called to be allies to one parent over another, resulting in extreme feelings of anxiety and fear on the part of these children. They should never be put in that position, but parents use that. When you're in an adversarial system, you look for components of what will up your power. And now, if you can get a couple
Sir,
kids on your side.
I'm going to need you to bring your remarks to a close.
Pardon me?
I'm going to need you to bring your remarks to a close.
Okay.
That was your 3 minutes.
All right. So my support of this bill is I believe you guys are at a historic place in terms of shifting, kind of a seismic shift in the whole perspective of getting away from adversarial resolution and moving toward a conciliatory and cooperative process.
Thank you so much.
Thank you very much, Doctor. My name is Richard Thomas, Thomas, from Loves Park, Illinois. I am a nurse. I'm a veteran. I'm co-author of this bill along with Attorney McGerhart, and most of all, I'm a father. As a nurse with significant mental health experience, psychiatric nursing, I've seen the emotional, psychological, and social fallout from children who do not have sufficient time with their parents due to court orders, not to general divorce chaos, but due to court orders. Like mentioned before, we're addressing something here that is systemic, that's long overdue for remedy. The standard, no matter how participatory or good a parent is, the standard is 4 hours a week and every other weekend. That percentage of time is insufficient to even bond, especially over the course of 18 years of a child's development. And so with that situation, with a systemic situation, it is time. It is time to change the antiquated laws that haven't been changed for many years. As Attorney Gerhart said, this 35% minimum weekly parenting time was a core essence of the bipartisan, Madigan bipartisan appointed Family Law Study Commission. As far as judicial discretion, this bill is loaded with judicial discretion. From 35% to 50%, that 15% chunk of judicial discretion is way more time than that is currently given with the 12% norm. So we're addressing a norm. We can fill this room with horror stories, but the norm from Chicago to Cairo is unacceptable, inefficient, antiquated, needs to be changed. The time to change is right now, and the time to do right is always right now. This bill is right for Illinois family law. We welcome any and all questions. Please vote wisely. This is a historical moment.
Thank you, Mr. Thomas. Representative Williams. Oh, I'm sorry.
No, Ron.
Oh, I'm sorry, Representative Sandak.
Proximity. John, I understand that Representative Burke has kind of an omnibus bill that I'm told has much of the same parameters within your bill in that overall bill. Any comment with respect to doing it piecemeal versus, again, by way of Representative Burke's omnibus bill?
With due respect to Representative Burke, I believe this has been going on for quite some time. There doesn't seem to be any resolution to it, so at this point we'd like to move forward to try to come to some sort of a resolution.
All right, let me just ask you this. Assuming, for instance, Representative Burke does begin to move her bill, and I think that there's an intent on her part to do so. We had hearings a few months ago, and I know that the family law study that you all have mentioned and some of the participants in that process have been very active, and they did at least 2 hearings in front of us, subject matter last time. Assuming the provisions in your bill are part and parcel or very similar to her bill, does it make sense to do one way or the other in your mind, given, I guess, again, the omnibus components contained in her bill?
From what I understand, it's not going to be the same as this.
Do you know the differences? I mean,
I'd rather not answer for Representative Burke.
Okay.
I respect Representative Burke, but I don't believe that I should be answering any questions on her part. We could always move this to second if it comes out of the committee and hold it until we see what is going to happen with Representative Burke, with the understanding that if it doesn't come forward, we would want to then move this bill. Because it just seems as though it's been hanging out there for way too long.
I know the difference. If the representative would allow me to delineate the differences between the Burke bill.
That would be great.
All right. The Burke bill is 1 inch thick. It's been going on for years after year after year. Children, and the main difference is taking that 35% minimum weekly parenting time that was a rock-solid core essence of that bill, of the recommendations, until clandestinely, recently, they were taken out. And I can explain that thoroughly when we have more time. But it's now replaced with a paragraph that says aspirational. We aspire to 35% minimum parenting time. Children don't spell love with the word aspire. They just don't spell that. They spell love, T-I-M-E. And today, they spell love, Y-E-S, on this bill. There's no need to wait. There's no downside. There's only upside to this. There's no downside. And I would declare anyone, point to this bill, that anywhere that it has to do with anything with domestic violence, anyone who actually wants to prevent domestic violence should be voting yes. Fair enough, thank you. I understand. Thank you so much.
Representative Williams.
Thank you. As you know, I've talked to many of you about this issue, and I'm certainly sympathetic to the needs of fathers in terms of the parenting relationship. Totally get that. Just hoping that we can find the best way to do it in a comprehensive manner rather than, again, the piecemeal doesn't seem to be usually the best way to approach this. So I, too, would want to maybe get a little bit more information and compare notes as to what is in Burke's omnibus bill, because actually, I think, from my recollection, the bill was actually called for for a vote. There were a few, Kelly pulled it out of the record because there were some concerns from a certain segment.
Representative, that was a different bill. That was the parentage bill.
Okay.
But she does plan on coming before the committee on Wednesday
Okay.
with her IND.
But either, okay,
bill.
so Wednesday we'll be discussing it, so that might be helpful. I mean, either way, if there are going to be duplications or differences, it should be worked out with them as part of a bigger, broader context. But my question on this bill specifically is, it mentions guidelines. Are these guidelines actually, or are they directives? In terms of the percentages and the presumptions, et cetera?
Mick, you want to take that, or me, or?
I'm actually reading in the analysis, so I don't have the actual language. But maybe you can just say, what does the bill require at a minimum? What is it going to mandate in terms of parenting?
Well, it defines best interest as a minimum of 35% parenting time. We're seeing that in several other states as well. Like I said, that was the words were directly from the Illinois Family Law Study Committee, minimum 35%. Gerald, directly from.
I guess, Mick, what prevents the judge from currently utilizing that standard? I mean, why do we need to mandate that and then possibly with a hearing change the percentage? Why wouldn't we just start with the best interest and then work forward?
Well, the reality of it is right now, the judge does every other weekend and one day during the week. I know our researcher here, Mr. Farrar, can pull rules from certain jurisdictions where they actually put in writing, this is what our definition of parenting time is, every other weekend, 4 days during the week for the non-custodial parent.
But so, that's not in the law.
But judges are actually writing it in their rules for their local jurisdiction, and that's what's being followed.
I mean, doesn't it make sense, though, that one size doesn't fit all? That's one of my concerns about this.
I agree one size doesn't fit all, but right now, that's exactly what we have. One size fits all. Every other weekend, 4 days during the week. Okay, that's the one size.
But not according to the law. I mean, if judges, that's not how the law is written, though.
Correct. Well, the 35% is based on lots of social science. Social science, I'm not sure if the doctor is prepared, but social science shows to maintain and keep a parent-child bond, you need 35% parenting time, and that's how that number came about. There's about 30 years worth of social science that supports this.
I mean, the thing about the residing with a non-custodial parent, that's not always going to work due to work schedules, et cetera. So I guess my confusion is, why start with a lot of parameters and then work from there, rather than not start with an open situation like the law requires and then work in the best
actually,
interest?
the parents
it seems a little bit
the parents actually get the first chance at picking their parenting plan. Right now, there is no first chance at picking a parenting plan. I'm an attorney. We go in, and it's just determined every other weekend, whatever. The parents don't even get a chance. This one tells the parents that they get the first shot at coming up with a parenting plan. That's where it should be. It should be with the parents.
So right now, it doesn't, if you go into court with an agreement, the judge doesn't regard it? Or I don't practice family law, so I don't know.
Because there is no thing defining what the agreement is, I can tell you, every parent who comes in, I'm going to tell you, you're going to win or lose. You're going to have a big battle here. You could be the every other weekend, 4 hours during the week, or you can be the other. And that's where all their money's going to be spent, because that's what it is. I bet you, I wouldn't even guess the percentage of people who are every other weekend. And one thing I want to point out, you said fathers does not have to do fathers. I'm willing to bet more of the people in the crowd here are mothers who are non-custodial parents than I have fathers as non-custodial parents in the crowd right now. So this is gender neutral.
Gotcha. Well, I appreciate it. I guess I'll look forward to continuing to hear from experts.
Can I add something? Can I add something? To me, this bill is going to shorten the bandwidth of, where conflict occurs and where resolution occurs. If it's from 0 to 100, that's a very wide bandwidth, and it opens up to so many different, potential situations. If the judge makes the discretion at 35 up to 50, the bandwidth of change is very short. Okay, and that's the standard that should be implemented when there are two fit parents. That is the issue. Kind of roots back into the Constitution, that children have equal access to their parents, parents have equal access to their children. And so this is a movement to try to get them to a place where they have a shorter bandwidth of differences. They should be able to work that out rather than 0 to 100.
I guess I just, not practicing this area. I look forward to hearing more testimony. However, I do share your concerns and interests for the non-custodial parent. I have seen examples personally, and Mick has shared with me, where the current system doesn't work. So again, I'm looking forward to working with you to get the best system. I'm just not confident yet, but look forward to learning more about this particular bill and how it might work to improve the situation of families in Illinois. So thank you.
Can I add
Representative Turner? No, I'm going to move on to Representative Turner.
Thank you, Madam Chair. Just a couple quick questions. I heard someone mention there may have been over 30 years of studies regarding getting to the 35% percentage point. Are there any other states that have legislation similar to this or have enacted laws like this?
There's several states. Actually, I'm going to say, I believe it's Arkansas that has the equal, they're using the word equal.
South Dakota.
What's that?
South Dakota is.
South Dakota is in the process of it right now.
Just signed into law.
Arizona is pretty much equal. Florida went equal. It passed the Senate and the House, but it was vetoed by the governor. Minnesota was at 45.1%, passed the House and Senate, but was vetoed by the governor. But they were pushing a lot higher than 35%.
Right.
When we know that similar bills at the 35% number and above, or where it's equal, is being pushed in several other states. They're working through the process right now due to committees.
Okay, thank you. And if I understood correctly, I don't know much about family law either, but if the parents currently come in with an agreement to the courts for an allotment of time that they've agreed to, that won't be honored by the courts?
No, it will be honored. However, right now, I'll tell you what happens. Client comes into office, they're getting a divorce, the battle begins. Because I know the winner, the standard winner is going to get 14%, the other one's going to get 86%. So now the battle begins, whether you like it or not. Yeah, if I have two parents who actually come in and say that they want 50-50, that's great. I've seen sometimes where the parents have actually come in. There's a case off the top of my head where parents actually came in 50-50 and the judge tried to convince them not to do that. The judge literally said, the only way you could do 50-50 if you love each other so much that you're going to stay married.
So although there's a provision included in the bill that you first look to parents to try to work this out,
correct.
You don't really believe that parents can work something like this out, or that it happens?
This bill gives full and complete opportunity, just said, the first 90 days in every divorce or separation, the parents themselves can do the right thing, step up and come to an agreed upon shared parenting plan. First 90 days. Then after that, it becomes a best interest of the child thing to limit the conflict, not maximize, minimize the conflict. And so that is why after that, then the court can step in with full and complete discretion,
right,
and
but I'm
order
just saying
anywhere from 35% to 50%, a huge chunk of discretion.
Given the adversarial nature that you say the parents come in to the courtroom, that although it's included in the bill, it doesn't sound like you really believe that parents or that there's an opportunity, if given an opportunity to work out an arrangement beforehand, the parents will actually come to some sort of agreement. And again, my original question was just currently, though, if they come in with an agreement, the court is fine to consider that and even accept it?
Yeah, I think the focus is really, shifting the whole emphasis away from the court is the only competent arbitrator of, dividing parenting time. And the shift is, no, the parents should be the primary focus of who has responsibility to make those kinds of decisions. We have such a litigious view of conflict resolution that we don't think parents have the capacity or capability to do that. And so, it automatically goes into this kind of adversarial process. But the reality is, parents a lot of times can get together, and if they can't, then they have to negotiate within the prescribed limits that the judge sets based on this bill.
Okay, great. Thank you.
And when you start talking about percentage of time, we get into the issue
20 seconds,
of...
and then we're going to move to the opponents.
I'm sorry?
I can give you 20 seconds, and we're going to move to the opponents.
Okay, last year, 10 members of this body voted yes on Senate Bill 10, clamored for marriage equality. No matter how much you, wherever you believe on that issue, one way or the other. This is also about parental equality. We need a yes vote. Those same 10 yes votes on Senate Bill 10 should be yes votes today.
Thank you.
Anything else would be inconsistent.
So I know we have some opponents in the audience. I think we were going to limit them to three testifiers or 3 witnesses, not testifiers. Really? Testifiers. You're going to testify when you're here now.
Jim?
And we will limit that to 3 minutes a witness as well. So if you can state your name for the record, and whenever one of you, whoever wants to go first, be my guest. Can you put your mic? Thank you.
Good afternoon. My name is Danielle Gomez. I'm an attorney with the Cook County Public Guardian's Office. The Cook County Public Guardian is court-appointed at the discretion of the court to represent children as child representative in custody cases in Cook County. The majority of the case, or all of the cases that we are appointed on, tend to be very contested child custody cases. We currently represent 780 children as a child representative in child custody cases pending in Cook County, and we always average about approximately that number at any given time of children. Again, we represent children, we do not represent parents in divorce cases. We are strenuously opposed to any type of presumption in a statute related to child best interest. The current statute already provides that one goal of the act is to maximize the involvement of both parents in the lives of the child, and we think it strikes the right balance and enumerates factors to consider in a child's best interest. There is nothing in the current act that prevents parents from agreeing to a plan that works for them and works for their child that's different. There is nothing that requires a court to order something specific, and that's really what we're opposed to in this particular bill. This bill would require, if parents don't agree, that the court enter a parenting plan that requires that the children either share time with the parents or that the parent have a minimum of 35% of the child's residential parenting time. There are so many factors that go into what is in an individual child's best interest. Their age, the proximity of the parents, even just week by week, whether you can fit in 35% if you have parents who live far apart from each other. There are a lot of things that factor into the child's best interest analysis, and the court needs to have that discretion to make that consideration. We are very concerned that this will actually increase litigation. Again, we're talking about these provisions applying to parents who haven't been able to agree on a parenting plan. So what happens if every week I'm entitled to 35%? And one thing that's difficult about raising kids is that they grow up. And they start to have their own lives, and they start to want to do things. So if I want to, my child wants to go spend the night at a friend's house, are we going to be in court because that week someone else didn't get 35%? If they have school activities, if they, there's a lot of different things, and we're very concerned about a shift, instead of looking at what is actually in a child's best interest, a shift to counting hours and counting minutes and, a child moving back and forth. There's nothing in the current statute that prevents families from equally sharing time. There's nothing that prevents a court from ordering that when it is in the child's best interest. But we are opposed to anything that mandates that. We also understand that the Chicago Bar Association is opposed to the bill for the same reasons that we're articulating today.
Thank you.
Oh, you're fine. Good afternoon, Madam Chairwoman, members of the committee. My name is Noelle Dupuis, and I'm the attorney with the Illinois Coalition Against Domestic Violence. We are a statewide membership organization to which the vast majority of domestic violence programs in Illinois belong, and I'm here to testify on their behalf and on survivors' behalf against House Bill 5425. To clarify a couple of things from the proponents, domestic violence is not fighting that begins at the outset of a divorce. It is a pattern of control and abuse that begins far prior to the separation. And so this bill would do nothing to alleviate domestic violence. And a bill does not need to touch the Illinois Domestic Violence Act in order to have a major effect on victims who are also subject to the Marriage and Dissolution of Marriage Act. Plenty of couples in Illinois right now do divorce amicably. In fact, according to the American Psychological Association, 80% of couples come to a divorce agreement at the outset. And as you have heard from many of our members through their written testimony, House Bill 5425 would be absolutely a devastating law for victims of domestic violence and their children. This bill will, in practice, result in most parents being subject to what is more commonly known as joint physical custody. Even though parents are not asked to share primary decision-making responsibility, they are required to have frequent and ongoing contact with one another, subjecting a victim and her children to potentially hundreds of more instances of abuse each year. This bill contains no exceptions for victims of domestic violence or abused children. In fact, it will require the victim to affirmatively challenge this presumption in court, subjecting her to a much higher standard of proof than is currently in place. It is already extraordinarily difficult for a victim to prove that she and her children have been abused in court. Institutional prejudice often results in victims not being believed by judges and law enforcement. And many suffer from post-traumatic stress disorders that make it difficult for them to tell their stories in court. Furthermore, even if she can overcome this burden, there's no way a judge can award anything less than 35% of the child's time to an abusive parent under this bill. This will likely result in many victims staying longer in abusive relationships because they understand that divorce will mean that they will not be around to protect their children during the mandatory and likely unsupervised 35% of their child's time. This presumption puts the interests of the parent before those of the children. So contrary to its stated purpose of, quote, continuing existing parent-child relationships, this presumption gives no consideration to a parent's prior involvement with the child, nor does it allow for an adequate venue for the child to voice his or her preferences. Rather, it requires courts to grant equal parenting time or a substantial amount of at least 35% of time to parents who are only meagerly involved with their children or unable to parent appropriately before the separation. This presumption will blindly elevate the rights of parents, even those who may be particularly bad parents, above those of the children. Children are already at a disadvantage in courtrooms when asked to speak up about physical or sexual abuse perpetrated by their parents.
I need to bring your remarks to a close.
Thank you.
Thank you. Mr. Covington.
Thank you, Madam Chairwoman. Jim Covington on behalf of the Illinois State Bar Association. We would adopt the remarks of Danielle Gomez as our own for our testimony. I'd be happy to answer any questions. Thank you.
Are there questions for the opponents for Representative Petty? Thank you.
For anyone on the panel, how do you reconcile this bill with, we've heard a lot of discussion about Representative Burke's bill. Is that, are these subjects discussed in her omnibus bill or not? If you know.
Yes, they are, Representative Betty. That was Jim Covington, Madam Chairwoman. I think she has a section in there. I just got the recent draft today, so I don't know exactly what it looks like. It's a 196-page bill, but I think there is a presumption in what they call the aspirational part of the bill, the rules and purposes of the act, that they put a recommended presumption in that part of the act.
John, have you talked to Kelly Burke about what she's doing? Because I think that, I don't want to speak for Representative Sandek and some of the others, but I think this committee likes the concepts of an omnibus bill, that we're not piecemeal.
I have spoken to Representative Burke, but without her being here, I do not wish to say what the conversation was, because you're only going to get my side. I don't think that's fair. I think she would need to be here as well.
Fair enough. What is your understanding as to what may occur?
I'd rather not answer that question.
Okay.
Because again, I respect Representative Burke, and I'd just rather not kind of give the conversation what we had without her being here.
Representative Sandak.
Thank you. Real briefly, Danielle, you used the term mandate, and I just want to make sure we're clear. I heard from the proponents that it's a rebuttable presumption, which is, well, frankly, it's significantly different than a mandate. There is a starting point upon which a party can advance or lose that rebuttable presumption. That's a fair characterization, wouldn't you say?
Well, the mandate would be at the 35% level, because it doesn't, this bill does not permit the court to go under the 35%.
Only above it?
Only above it.
Okay, that's a good distinction. Thank you.
If they're good and fit.
Representative Williams.
So just to clarify, Danielle, what you just said, so the section which provides for 35%, that is if you can't get the 50%, the equal, and then the 35% is nothing to do with any sort of criteria as to any the child's best interest in terms of emotional health, moral health, or morals, mental health. That language doesn't apply to the 35?
I believe it says if the court doesn't find that the 50% is appropriate for the child, that it shall order 35%.
I guess my comment is just general. It seems like on this bill and other ones that relate to the non-custodial parents' rights, it seems like the proponents with with good reason are looking to pass a law to address some inequitable situations, but then having the law apply to everyone. Whereas it seems like, and I'm going to say also, you guys are opposed to the bill for, I think, what's for the people that are, and the families and parents that are exceptions, not the rule. Does that make any sense? So, for example, there's been some other bills that deal with non-custodial parents, and I've been shocked to see the DV community opposed to it, because most of the non-custodial parents and fathers that are trying to get custody and are treated unfairly in these situations for whatever reason, whether it's a bad judge, inadequate resources, things like that, they're not abusers. They just want to see their kids. So I think both sides are kind of playing to the extreme situations, and that's why I feel that there's got to be somewhere where we can provide maybe there's a better way of doing it than we do have in current law. But the 35%, I can see Danielle's point. As far as your guys' point, I think you need to be more open that just because this deals with the non-custodial parents, and yes, there are situations where there's dangerous situations for families and children to be in, certainly that doesn't, paint a broad brush over the vast majority of parents and the fathers and mothers that are just desperate to see their children or find themselves lost in a really rough and very unfriendly court system, especially when they don't have the means to hire a lawyer to fight for them all the time.
Can I add to
That's
that?
kind of just a comment, not so much a question.
Right.
So that's what I'm struggling with here, and I just wanted to share that from both sides. I see, I'm not comfortable with either approach necessarily.
So with that, I'm seeing no other questions from members. I'm going to, Representative Welch makes a motion do pass on.
Madam Chair, may I close?
Oh, I'm sorry, Representative Capello, of course.
Thank you. Madam Chair and members of the committee, again, I'd be open to holding this on second till we find out what Representative Burke's bill is. If it doesn't come in a timely manner, though, I would ask that we would then be able to move this bill. I don't believe that this bill is going to cure domestic violence, nor do I believe that this bill is going to assist in domestic violence. There comes a point in time where I believe that we've got to start giving, and it doesn't matter if it's the father, and it doesn't matter if it's the mother, we've got to start giving children the opportunity of being to have both parents involved. This is not about mom, this is not about dad. This is about the kids that mom and dad have together as two people. It's not just one, it's two people. So we've got to find a way of moving forward to making sure that children have access to both their mother and their father. I respectfully ask for an aye vote. Thank you.
Representative Capello, then if we were to get this bill out of committee, if Representative Burke's bill did not move, then you would want to call it and
Yes,
not bring anything back to committee then?
If it pleases the committee, I could bring this back, but I guess we would need to try to come up with some sort of time frame so that we don't run out of time with all the rules that are in place.
Because here's my concern is I, like a lot of what I'm hearing from the committee members, believe that this is a direction we need to be moving. I don't happen to think that this particular bill is the right bill. And I don't know what's going to happen with Representative Burke's bill because it is a significant rewrite. So I don't want to be in a position where we put this bill on second reading and then you call it without it coming back to this committee, because I believe the bill needs some work. So I don't know what the rest of the committee thinks. But if you're committing to then working to come up with an amendment that could pass this committee, I'm happy to let that happen. Otherwise,
I think we've heard today that I don't know if there's going to be ever a time that we can come to an agreement on this bill. So I would probably say no, then I'd request for a vote.
Okay. With that, Representative Welch moves do pass on House Bill 5425. Clerk shall call the roll.
Nekritz. Williams.
I just want to say I do agree with the chairwoman and that this is going in the right direction. At the same time, I do think that the fact if we don't move it forward, you won't have a seat at the table necessary to advance your perspective and on this issue. And I do understand the importance of having all or both parents really have a shot at being involved with their children's lives. And I think all too many times that doesn't happen for whatever reason. Again, I don't agree necessarily with what we have in the bill, but I hope you have a seat at the table. So I'll vote yes to get out of committee.
Sandak.
John, I favor the concept that Representative Burke's doing. However, I think I'm going to vote yes because I think, by and large, this is the right framework and structure. I agree with my colleague to the left, however, that I have some problems with some of the substance, so I'm going to vote yes to move it out of committee.
Anthony?
Yes.
Drury? No. Hoffman?
No.
Kay? Yes. Sims? Stewart?
Yes.
Tepetti? Turner?
Representative Cabello, I know we've had a lot of discussion concerning this bill, and I gave you my commitment to help you work because I agree with the concept in general or the direction that you're moving in. So I would hope that if a more omnibus approach or Kelly Burke's bill is the way to go, that we would go that direction, that you'd continue to have those discussions with her, but you have my yes vote coming out of committee.
Welch?
Representative, I joined you as a co-sponsor, and I commend you for the work you've been doing on this bill. I do hope you're listening to the committee and work with Representative Burke on hers as well. 12 years on the school board, I've seen too many kids without fathers in their lives, and I've seen the results of that. So I think this is something that's very important, and I do join you in voting aye on that.
Brown? Yes. Walsh?
Yes.
Harris? Tepetti?
John, if I understood you correctly, that even if it gets out of committee, and it's going to do that obviously today, are you saying that what Kelly Burke is doing is, for lack of a better way of putting it, somewhat irrelevant to what you're trying to do here this afternoon? And I only ask that because I think, I don't want to speak for all the members of the committee, but I think that we kind of like the feel of having an omnibus proposal that puts in as many aspects of the substantive law as possible into one bill. So I want to make sure that I understood where you stand as far as your discussions with Representative Burke, working with her, incorporating your ideas into that omnibus bill, or if you're not willing to do that at all, that you just kind of want to fly solo.
But answering Chairwoman's questions, I think at this point,
I just want to make sure that I understand.
I haven't seen Kelly Burke's bill.
But you had a conversation with her, though.
Yes.
But you don't want to talk about it. That's fine. But
I will wait. I mean, obviously, it's not going to go tomorrow. Apparently, she's going to present the bill here on Wednesday. We now have an avenue of maybe coming together a little bit more collectively now that we've got an avenue out. So,
present.
On a vote of 9 voting yes, 3 voting no, 1 voting present, House Bill 5425 shall be favorably reported to the floor. Thank you.
Thank you, Madam Chairman, members of the committee.
The Illinois Channel's coverage of the state legislature is underwritten by the Illinois Trial Lawyers Association.